We're here on the bond violation. They were sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you wanted to say before I?
Yes. But I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time.
0:001:50. This situation didn't begin with confusion. It began with a firm refusal to follow the court's rules. It wasn't about missing documents or a mix-up. It was a deliberate decision to avoid taking responsibility. Yes, she was a young mother, but she was also someone facing serious charges related to driving under the influence. The court didn't just see her as a parent, it saw someone who had admitted to going over the legal alcohol limit and then delayed following instructions. When she was told to wear an alcohol monitoring device, she hesitated. She mentioned childcare responsibilities and feeling overwhelmed. But the law doesn't pause for life's challenges. It expects everyone to follow through, no matter their circumstances. This was the first major concern, and it was clear for the court to see. A warning sign that wasn't just overlooked by her, but also by those who hoped she'd approach the process with the seriousness it required.
The kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Ms. Wilson, is that on the 17th you admitted to the violations. I set the sentencing out to today. In the interim, because there was a dirty blow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Can I talk?
Yeah.
I worked both.
What'd you say?
I work Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
The court wasn't convinced. The judge listened closely, questioning every excuse she gave. Why did she wait until nearly 4 p.m. on a weekday to follow through? Why wasn't there any earlier sign of cooperation? Where were the required test results? Her reasons included not having a babysitter, no transportation, and a busy work schedule. But to the judge, these sounded less like real obstacles and more like attempts to explain away inaction. When you're under a court order, participation isn't optional. It's expected. Each excuse seemed less like a genuine difficulty and more like a way to delay. And with each delay, the picture became clearer, not of someone facing impossible challenges, but of someone who wasn't treating the process with the seriousness it demanded. In court, what matters most isn't what you mean to do, it's what you actually do. And in this case, her actions didn't show commitment. They showed a lack of follow-through.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad. Or he can come get his kid, that's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, not watching. Yeah.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober one, right? The alleged blood alcohol content was 0.085. There was an accident. During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said, because I got the tether.
Oh, I know.
Oh.
5 days late.
This wasn't about harsh punishment right away. In fact, the system gave her a chance, a way to avoid jail. The court offered her time, support, and the benefit of the doubt. She was asked to prove she was serious, show up, take the tests, follow the rules, but that didn't happen. There were no steady updates, no real progress, no sign of urgency. When the court expected action, she stayed silent. Yes, she wore many hats: student, mother, employee. But instead of stepping forward, she seemed to use those roles as reasons not to engage. That wasn't effort, it was avoidance. Being busy doesn't mean you can't be responsible. In her case, busy felt more like a polished excuse than a valid reason, and slowly, the court's patience began to wear thin.
So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober link either.
Yeah, because the device locked. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right. Yeah.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link. On the 18th, it gave her an error that it had to be reset.
And you did nothing.
Supposed to bring my kid in there. I can't.
But you did nothing. And then let me ask you this. Do you not take this seriously at all?
I do take it serious. Yeah, I'm busy. I'm a very busy person.
Okay.
And that's not an excuse,
We all are.
but it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient. It's all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient.
At its heart, this case wasn't just about missed tests or being late. It was about a DUI connected to a real crash. Her blood alcohol level was 0.085. That's not a small mistake, that's serious. Someone could have been badly hurt, or worse even after that. She didn't act with the urgency the situation called for. The alcohol monitoring device, meant to ensure she was staying on track, wasn't put on in time. Days went by without any real oversight. This wasn't a paperwork error, it was a public safety concern. The court gave her the opportunity to rebuild trust. Instead of taking it, she let it go. And when you're offered a path forward, it's up to you to use it, or risk facing the consequences of doing nothing.
But if true, no one in this room is the cause of that inconvenience except you.
Right.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her,
but Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, well, let's say 20 violations of basically, well, actually it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one,
Some people tried to defend her, pointing out that she was only 21 and that this was her first offense. But the judge didn't see that as a reason to look the other way. Youth might explain a lack of experience, but it doesn't excuse responsibility, and this wasn't a single mistake. There were nearly 20 different times she didn't follow the rules. Not just 1 or 2 missed tests, but a repeated pattern. Missed appointments, skipped check-ins, and no consistent effort to stay on track. She had plenty of chances to show she was trying. The court wasn't asking for perfection, just some sign that she was taking it seriously. But that sign never came. What the court saw, over and over, was a lack of priority given to even the simplest responsibilities. And in a courtroom, that kind of behavior doesn't go unnoticed.
then even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test on 2 occasions for her testing that day between 7 and 10 a.m. and 2 to 5 p.m. She didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month.
This wasn't just a rough week. It was a complete failure to follow the rules. Between April 5th and April 14th, she missed almost every scheduled test, morning, afternoon, and evening. She was supposed to check in using the SoberLink system, but she didn't after that. The excuses followed. She said her child needed her. She claimed the technology wasn't working, but the court had heard these reasons before. This wasn't a single mix-up or a forgotten date. It was a clear pattern of not following through. Her actions spoke louder than her explanations. And eventually, even the most understanding system reaches its limit. The court saw her losing control, and her credibility was no longer holding up.
And then she appears before me on the 17th. I give her a break by not remanding her. And tell her that she has to get a tether. And then I get here, I'm now, and set this out to the 24th, and now I get here, and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just,
Yeah.
I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further mistest, Your Honor. If she's able to continue on to bond.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out in bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You missed going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it. In fact, so that we're also clear on the 19th.
Then came the breaking point. Community corrections, the team assigned to help her stay on track, ended their involvement. She stopped showing up, even after agreeing that she would. The only reason she wasn't facing more serious consequences was because someone else, not her assigned officer, stepped in at the last moment and helped get her monitoring device installed. It was an act of grace, one more effort to keep her from walking into court completely unprepared, but the judge wasn't swayed. He saw it for what it was, a last-minute save, not a sign of real progress. And that was the end of the leniency. No more second chances. No more excuses. All that remained was the final decision, clear and firm.
Even if I accept your rationale that you were working, and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't. Monday, you weren't working, and you still didn't go until late, actually after the agent that's assigned to your case at Community Corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether. Because otherwise you'd be showing up today with no tether. And mind you, the person that did that did it after the agent that's assigned to your case had terminated you from community correction supervision because you weren't compliant. Anything else?
And further,
Lady, you're going to have to learn to just pay attention. When court tells you to do something, you're going to have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. It's a sentence of the court. Defendant remanded to the Washtenaw County Jail to serve 5 days for the violations to date. Mr. Allen, you may take her.
The gavel didn't need to slam in anger. It didn't have to. The judge's words were calm, clear, and final. The line had been crossed. She was sentenced to 5 days in jail, not out of harshness toward a young mother, but because the court had run out of options. Her continued refusal to cooperate wasn't just about her. It put others at risk, and there was no sign she was willing to change. Looking her in the eyes, the judge delivered a message that cut through everything. This isn't all about you. That single sentence carried more weight than any long speech. She had reached the end. No more time, no more chances, and nothing left to explain. Justice didn't come with anger. It came with truth, measured, firm, and long overdue.